Imagine you're a contractor, right? Sitting at your desk late at night,
Yeah.
and you're just staring down a deadline.
Yeah, we've all been there.
Exactly. And a massive city project just opened up for bidding. It's a brand new civic library. So you run the numbers, you check the supply cost, and you furiously type out your bid.
Right.
You mean to offer to build this library for $900,000.
Mm-hmm.
But it's late, your eyes are tired, and you accidentally drop a single zero.
Oh, no.
You hit submit. You've just offered to build a multi-million-dollar city infrastructure project for $90,000.
Which is a complete disaster.
A total disaster. The city receives it, sees this unbelievably low number, and instantly accepts. So you wake up the next morning bound to a contract that will literally bankrupt your company, liquidate your assets, and ruin your life. Or, are you actually bound?
Right. And that is the ultimate nightmare scenario for anyone in business. It cuts straight to the heart of what we're doing today. Because the instinctive assumption we all have is that a signed contract is just, well, it's a locked vault. The offer was made, the acceptance was given, the consideration is right there on paper.
But the reality of contract law is entirely different, isn't it?
Totally different. That vault actually has a dozen hidden escape hatches built right into the floor.
And finding those escape hatches is our absolute mission for this deep dive. We are tearing into a stack of your legal sources today, specifically targeting Chapter 4 of the materials you're using for your bar prep.
Chapter 4, the requirement that no defenses exist.
Exactly. We're looking at the legal mechanisms that can take what looks like a perfectly valid standard contract and just completely obliterate it.
And just to set the table for you as you listen and study, we need to bypass the introductory steps.
Right.
Like, we are assuming you already know the mechanics of mutual assent.
Right. The basics are already covered.
Yeah, we're assuming you understand the bargain for exchange of consideration. We're not going to hold your hand through the definition of an illusory promise today.
We're skipping straight to the advanced stuff.
The high-yield traps at the multi-state bar examination, the MBE absolutely loves to test. Our goal is to translate these really dense historical common law doctrines into plain English.
Because if you understand why the courts develop these rules, the rote memorization just becomes secondary.
Exactly. You'll just know how the mechanism works intuitively.
So I want to start by looking at the concept of the meeting of the minds. Because before we get into the cinematic stuff, the fraud, the blackmail, the extortion.
Stuff.
Right, the fun stuff. But before that, we have to look at simple human error. What actually happens legally when two people shake hands, but their internal monologues are entirely disconnected?
Yeah, if the meeting of the minds was actually a total collision of misunderstandings, does the contract survive?
Often it doesn't. But from what I read, the law requires us to be pretty surgical about what kind of mistake actually occurred.
Right. It does. So the first major doctrine here is mutual mistake. And this applies when both parties are mistaken about a basic fact that existed at the exact moment the contract was formed.
Both parties, okay.
Right. And if that happens, the contract is generally voidable by the party who is adversely affected. But, and this is key, the bar examiners know that students tend to apply this way too broadly.
Oh, I bet.
Yeah, there are 3 highly specific requirements that you must meet to successfully deploy a mutual mistake defense.
Okay, let's hear them.
First, the mistake must concern a basic assumption on which the contract was made. Second, it must have a material effect on the agreed exchange of performances. And third, the party seeking to avoid the contract must not have borne the risk of the mistake.
Let's dissect that third element. Because bearing the risk feels like the pivot point where most of these cases either win or lose.
It absolutely is.
Like if I go to a police auction and I bid $50 for a sealed, locked footlocker that was abandoned in a storage unit, I'm actively embracing uncertainty there.
Right, you have no idea what's inside.
Yeah, I'm hoping there's a vintage guitar in there, but I know it might just be full of old phone books. If I crack it open and it's phone books, I can't run to a judge and claim mutual mistake just because the auctioneer also didn't know what was inside.
You can't. And you're touching on the concept of conscious ignorance, which is actually formalized in the restatement second of contracts.
Conscious ignorance, I like that phrase.
It's very descriptive. When you bought that footlocker, you were consciously aware that you had limited knowledge, but you treated that limited knowledge as sufficient to make the deal anyway.
So the law says I explicitly assumed the risk.
Exactly. Therefore, you cannot rescind. The courts are protecting the finality of the auction. But Contrast your Foot Locker with a situation where neither party thinks there is any uncertainty at all.
Okay, give me an example.
Let's say you and I are at a flea market. We're both looking at this dusty, yellowed stone. We both examine it, and we both honestly agree, based on our limited layperson knowledge, that it's just a piece of semi-precious topaz.
Okay, a topaz. Got it.
And I sell it to you for $50. You take it to a gemologist the next day, and they tell you it is an incredibly rare, uncut yellow diamond worth $50,000.
Oh, wow. So as the seller, I'm going to want to tear up that contract immediately.
Naturally.
But did I assume the risk? I mean, by selling a rock I hadn't formally appraised, wasn't I exhibiting conscious ignorance?
You'd think so, but the historical case law actually says no. The most famous case mirroring this is Wood v. Boynton from the late 1800s, and courts have wrestled with it for a century.
So what's the modern synthesis for the exam?
The modern rule is that if both parties operated under the absolute, unquestioned assumption that the item was a topaz-like, a specific fundamental identity of the subject matter, then neither party assumed the risk that it was a fundamentally different substance.
Wait, really? So the seller gets the diamond back?
Yes. The seller can successfully rescind the contract because the mutual mistake went to the very root of what the thing was, the identity of the item itself.
Okay, but hold on. What if we change the facts slightly to get at that first element you mentioned? The basic assumption versus a mistake about value.
Let's do it.
Let's say I hire a construction company to dig a foundation for my new house. The contract is for $20,000. The builder brings in his backhoe, digs down 3 feet, and hits a massive, unmapped shelf of solid subterranean granite.
Ouch. That's going to be expensive.
Exactly. It's going to cost him $80,000 in diamond-tipped drills and dynamite just to finish the job. Neither of us knew the granite was there. We were both mutually mistaken about the soil composition. Can the builder void the contract?
If the builder tries to claim mutual mistake there, the court will almost certainly deny it. The builder is going to take the financial hit.
But why? How is the hidden granite different from the hidden diamond? Neither party knew about the fundamental reality of what they were dealing with.
Because the law implicitly allocates certain risks based on industry custom and the nature of the relationship.
Oh, so because he's a builder?
Right. A builder who contracts to excavate land is generally presumed to bear the risk of unexpected soil conditions, unless the contract explicitly says otherwise, like including a changed conditions clause.
So the law essentially says to the builder, you were the professional, you had the opportunity to take soil samples before bidding, you chose not to.
Precisely. You assume the risk of your own profitability, and the MBE absolutely loves to test this exact distinction.
So mutual mistake is rarely a successful defense when it's just about value or profit.
Very rarely. If the mistake merely concerns the value of the deal, the profitability of the contract, or just a bad prediction of future market conditions, the contract stands.
Like if I buy a stock from you,
Right.
we both think the company's going to release a hit product, but it flops and the stock tanks.
Exactly. We were mutually mistaken about the future, but we were just gambling on value. The contract stands.
Okay, so mutual mistake requires a fundamental flaw in the identity of the thing being traded, where neither party rolled the dice. But what about my opening scenario?
The contractor dropping a zero.
Yeah, because the city wasn't mistaken there. They knew exactly what the bid said, only the contractor was mistaken. That's a unilateral mistake. Is he doomed?
Well, the general baseline rule of contract law is that a unilateral mistake does not excuse the mistaken party.
Which makes sense.
It does, because the system heavily favors the objective manifestation of assent over subjective hidden intent. If you sign a paper saying you'll sell your house for $100,000, the buyer gets to rely on what the paper says, not what was secretly in your head.
Right.
However, the trapdoor opens if the non-mistaken party either knew or had absolute reason to know that a mistake had been made.
Oh. So in the library bid scenario, if every other contractor bid around $900,000 and our guy bids $90,000, the city officials can't just rub their hands together and say, gotcha.
Precisely the opposite of a gotcha. The law imposes a standard of good faith. If the disparity is that massive, the city has reason to know that a clerical error occurred.
It can't just snatch up an offer that's too good to be true.
Not if any reasonable person would realize it was a typo. The contractor will be allowed to rescind. But notice the specific nature of the error you set up in your hypothetical. Dropping a zero. The law categorizes that as a mechanical error.
As opposed to an error in judgment.
Right.
Like, what if the contractor bid $900,000 but he just totally miscalculated the rising cost of steel. He didn't drop a zero, he just made a terrible business prediction.
If it is an error in judgment, the contractor is entirely out of luck.
Even if the city knew he was underestimating it.
Even then, the city has no obligation to correct his bad business acumen. The law protects victims of slipped decimals. It does not protect victims of their own poor forecasting.
So for the MBE, you have to look closely at the fact pattern to see if the unilateral mistake was mechanical or judgmental.
Absolutely.
Okay, so let me trace the logical timeline for a bar prep student here. Let's do a quick recap.
Right.
You look at a mistake scenario. First, ask, were both people wrong or just one? If both, is it about the fundamental identity of the thing or just its value? If it's identity, the contract is likely voidable. If it's just value or profit, the contract stands.
Perfect.
Now, if only one person is wrong, the contract stands, unless the other party knew or should have known it was a mechanical error.
That is a very clean analytical framework.
Awesome.
And we have to add one more layer to this misunderstandings category, which involves intermediaries and ambiguous language. What if the mistake isn't in your head, but in the transmission of the message?
Let's use an agency hypothetical for that. Say I'm selling a commercial property. I tell my attorney to draft an offer to a specific buyer for $3,130,000, $3.13 million.
Okay.
My attorney drafts the letter, but typos it as $3,300,000, $2.3 million. The buyer signs it. Am I bound to sell my property for $3.3 million, even though I explicitly instructed my agent otherwise?
Yes, you are. The rule for transmission errors is that the message as transmitted governs the contract. You chose the intermediary, in this case, your attorney, so you bear the risk of their mistakes.
So the buyer gets the benefit of the bargain.
Exactly. The buyer is the innocent party relying on the objective text of the offer they received. Your recourse is to sue your attorney for legal malpractice, not to invalidate the contract with the buyer.
But wait, doesn't that conflict with what we just established about unilateral mistakes? If the buyer should have known it was a typo, couldn't I avoid it?
You're connecting the doctrines perfectly. Yes, the transmission rule has the exact same exception.
Oh, nice.
If the property had been listed for months at $3.1 million and suddenly an offer comes over at $3.3 million, the buyer might have reason to know a mistake was made, and then the contract wouldn't be formed on the mistaken terms.
But assuming it's a completely plausible number, the transmitted message wins. Let's push further into the language itself. What if there's no typo, no drop zero, but the words used in the contract legitimately have two completely different, reasonable meanings? The source material refers to this as ambiguous contract language, specifically latent ambiguity.
This is a favorite concept of law professors everywhere because it stems from one of the most famous cases in English common law history.
Raffles v. Wichelhaus.
Yes, commonly known as the Peerless case. It perfectly illustrates latent ambiguity. In the 1860s, two merchants entered into a contract for the sale of a large shipment of cotton.
Okay.
The contract stated the cotton would arrive in Liverpool on a ship named Peerless sailing from Bombay.
So it sounds like a perfectly clear contract.
Yeah.
The identity of the goods is set. The delivery vessel is named.
It was entirely clear on its face. The ambiguity was latent meaning hidden until the time of performance, because it turned out there were two different ships, named Peerless sailing from Bombay to Liverpool.
You're joking. Two ships.
Two ships. One was scheduled to arrive in October and the other in December. The buyer meant the October ship because he needed the cotton quickly.
And the seller meant the December ship.
Exactly, because he didn't have the goods ready yet. So when the December ship arrived, the buyer refused to pay, saying the contract was breached in October.
They both thought they had a meeting of the minds, but they were thinking of completely different ships. So how does a court unravel that? Does one side win?
The court established a rule that we still use today. If neither party is aware of the ambiguity, or if both parties are equally aware of the ambiguity but still intend different meanings, there is no contract.
The mutual assent was a complete illusion.
Right. The contract is void. However, the modern rule adds a critical protection mechanism.
What's that?
If one party knows about the ambiguity, say, the seller knew there were two ships, but the buyer only knew about the October ship, the contract is formed based on the meaning understood by the innocent party.
Wow. So the law punishes the party who held the hidden knowledge and failed to clarify.
Exactly.
So if I know the word we are using has two meanings, and you don't, I am legally bound to whatever meaning you assumed. That puts a massive burden on the party with superior knowledge to draft clearer contracts.
It does, and that's exactly the policy goal the courts are aiming for. They want to force the party with more information to share it, thereby reducing litigation down the road.
Okay, let's shift gears from honest misunderstandings and clerical errors into the darker territory of Section 2. We're talking about active lies, hidden truths, and intentional deception.
Misrepresentation and fraud.
Yeah. If we sit down at a negotiating table and I look you dead in the eye and state a fabricated fact to get you to sign, I imagine the law is going to be incredibly harsh on me.
It is, but the innocent party still has to prove specific elements to actually get the contract voided.
Okay.
At its core, a misrepresentation is simply an assertion that is not in accord with the facts. For a misrepresentation to make a contract voidable, the innocent party must prove that they had justified reliance on the false statement,
Justified reliance.
and that the statement was either fraudulent or material.
I want to break down that fraudulent versus material distinction, because honestly, they sound interchangeable to a layperson.
In contract law, they represent two different paths to the exact same result. Fraudulent misrepresentation, which is often called fraud in the inducement, requires scienter.
Scienter.
It's a legal term, meaning the maker of the statement either knew it was false or made it with reckless disregard as to whether it was true or not.
So there was active intent to deceive.
Yes. Material misrepresentation, on the other hand, doesn't necessarily require evil intent.
Oh, really?
Yeah, a statement is material if a reasonable person would likely be induced by it to manifest assent, or if the maker knows that this specific person is likely to be induced by it, even if the maker didn't consciously know the statement was false when they made it.
Okay, so let me give you an example. If I'm selling a house and I tell you the foundation is solid concrete, but it's actually crumbling brick. If I knew it was brick, that's fraudulent. But what if I genuinely, honestly believed it was concrete because the previous owner told me so? I didn't intend to deceive you at all.
That is an excellent hypothetical. If you honestly believed it, it's not fraudulent. However, the structural integrity of a foundation is obviously a massive factor in buying a house.
Definitely.
A reasonable person would absolutely be induced to buy or not buy based on that fact. Therefore, it is a material misrepresentation.
So even though I didn't mean to lie,
Because it was material and the buyer justifiably relied on your statement, the buyer can still void the contract. The court is saying even though you didn't mean to lie, the fundamental premise of the bargain was so compromised that it's unfair to hold the buyer to it.
let's drill into that concept of justified reliance.
Yeah.
Because I can imagine a scenario where the seller says, hey, this used car has brand new brakes. And I just take their word for it. I don't look at the wheels. I don't ask for a mechanic's receipt. I just nod, smile, and sign a 20-page purchase agreement. Later, the brakes fail on the highway. I try to sue for misrepresentation.
Okay, let's see how this plays out.
The dealer's lawyer holds up the contract I signed, points to page 18, and reads a clause that says, buyer acknowledges the vehicle is sold totally as is, and seller makes no oral warranties regarding the condition of any parts, including brakes.
A classic boilerplate clause.
Right. And the lawyer looks at the judge and says, Your Honor, my client might have lied, but the buyer was an idiot for not reading the contract. His reliance wasn't justified. Who wins that argument?
This is a classic tension between the duty to read and the doctrine of fraud. Historically, courts leaned heavily toward the written document.
So the buyer would lose.
Historically, yes. But the modern trend, and the rule you should apply on the MBE, is that a party's failure to read the contract does not automatically preclude them from asserting justified reliance on a fraudulent misrepresentation.
Really. So the active liar loses to the lazy reader.
Yes. The courts have decided that as a matter of public policy, it is worse to reward an active, intentional deceiver than it is to protect a negligent or trusting victim.
Wow.
If the dealer looked you in the eye and lied about a specific material fact to induce you to sign, they cannot use the boilerplate language of the contract as a shield against their own fraud. Your reliance on a direct, factual assertion can still be deemed justified by a jury.
That feels incredibly protective of the consumer. Now, what if the dealer doesn't actively lie, but just stays quiet? We're moving into the realm of concealment and non-disclosure.
Yes.
Like, the dealer knows the transmission is about to explode, but I never ask about the transmission, so they never bring it up.
This is where we have to separate active concealment from mere non-disclosure. Active concealment is treated exactly the same as an affirmative lie.
Okay, give me an example.
If the dealer knows the engine block is cracked and they intentionally weld a piece of scrap metal over it and paint it to look normal so you won't see it during your inspection, that is active concealment.
And the contract is voidable.
Correct.
But what if they don't paint over it? They just park the car in a dark corner of the lot and hope I don't look closely.
Under traditional common law, mere non-disclosure, just staying silent, was not considered misrepresentation. The doctrine of caveat emptor, buyer beware, reigns supreme.
But I'm guessing that's changed.
It has. Modern law has created substantial exceptions where a party actually has an affirmative legal duty to speak up.
What triggers that duty to speak?
There are a few triggers, but the highest yield one for the bar exam is the duty to update a prior statement.
Oh, like if something changes.
Exactly. Suppose we are negotiating a corporate merger over 6 months. In month 1, I truthfully tell you my company has 0 pending lawsuits. But in month 5, a week before we sign the final papers, my company is hit with a massive class action lawsuit.
Oh, man.
Even though my statement was 100% true when I made it, I now have an affirmative duty to disclose the new information.
So if you stay silent,
If I stay silent and let you sign, assuming my month 1 statement is still accurate, my silence is legally equivalent to a fraudulent lie.
okay, so whether by active lie, painted over crack, or failure to update, a fraud has occurred. The MBE tests this heavily, and there is one distinction I know students constantly trip over.
Let me guess. Fraud in the inducement versus fraud in the factum.
You got it. I want to spend real time on this because the legal result of each is entirely different, isn't it?
It is a vital distinction. Everything we have discussed so far, the lies about the brakes, the hidden granite, the fake foundation, all of that falls under fraud in the inducement.
Because the lie induced me to sign. I knew I was signing a contract for a car or a house or a company. I intended to legally bind myself to a transaction. I was just operating under false pretenses created by your lie.
Exactly. And because you did intend to sign a contract, the law makes the resulting agreement voidable at your option.
So the power rests with me.
Yes. Once you discover the lie, you can say, I want my money back, the deal is off. Or, hypothetically, if you discover the lie but realize the deal is actually still incredibly profitable for you, you can choose to ratify the contract and enforce it against the liar.
So what is fraud in the factum then? How can it be worse than lying about a foundation?
Fraud in the factum, which is sometimes called fraud in the execution, occurs when you are tricked into signing a document without even understanding that it is a contract at all,
Wait, how does that happen?
or without understanding its essential terms because of a trick or sleight of hand. Let's create a scenario to illustrate this.
Let's do it.
Let's say an elderly man is legally blind. His nephew brings him a stack of papers and says, Uncle, these are the birthday cards for the family. I just need you to sign the bottom.
Okay.
The uncle signs them. But the last piece of paper in the stack is actually a deed transferring the uncle's house to the nephew.
Wow. That is incredibly dark.
It is, but it's the perfect, classic example of fraud in the factum. The uncle had absolutely zero intent to enter into a legal transaction. He thought he was signing a birthday card.
So is voidable.
No. In this scenario, the contract is not voidable. It is entirely, utterly void from the moment the pen left the paper. It simply does not exist as a legal instrument.
Let me push back on that. Why does the law make such a hard line between voidable and void here? What's the practical difference? If the uncle wants his house back, doesn't voidable get him the exact same result as void? He just cancels it.
The practical difference becomes massive when third parties get involved. Let's trace the ripple effects.
Okay, walk me through it.
Suppose you buy a painting from me, based on my lie that it's an original Picasso. That's fraud in the inducement. The contract is voidable.
Right.
But before you discover the lie and void the deal, you turn around and sell the painting to an innocent art gallery. Because you held a voidable title, the innocent gallery might actually get to keep the painting under certain UCC rules, and I would just owe you damages. But now look at the blind uncle. The nephew takes that fraudulent deed and immediately sells the house to an innocent third-party buyer who has no idea about the trick.
Oh?
If the deed was merely voidable, the innocent buyer might have a claim to the house. But because it was fraud in the factum, the deed is void ab initio void from the beginning. It's as if it was a blank piece of paper.
So the nephew never had any legal title to transfer in the first place.
Exactly. Therefore, the innocent buyer gets nothing, and the uncle gets his house back immediately. The void label is absolute armor against the rest of the world.
That makes the distinction crystal clear for our quick recap here. Fraud in the inducement means I knew I was making a deal, I just got lied to. Voidable.
Yep.
Fraud in the factum means I didn't even know I was making a deal. Void completely.
You've got it. And that leads us logically to the next layer of defenses in Section 3. We've covered mistakes about the facts and lies about the facts. Now we have to look at the people themselves.
Capacity and public policy.
Exactly. Even if the facts are clear and true, the law demands that the people sitting at the negotiating table have the legal standing to actually bind themselves to a promise.
So we are asking who is legally allowed to make a deal. Let's start with the most common capacity issue, minors. Or, as the historical common law insists on calling them, infants.
Yes, infants. In almost all jurisdictions today, the age of majority is 18. The foundational rule of the infancy doctrine is that any contract made by a minor is voidable at the option of the minor, but it is completely legally binding on the adult who entered into it.
It is a totally one-sided street. The teenager holds all the power.
Entirely one-sided. A minor can choose to enforce the contract if it benefits them, or they can disaffirm it, meaning cancel it, at any time before they turn 18, or within a reasonable time shortly after turning 18.
Let's push this to the extreme to see how the mechanics of disaffirmance actually work. Because I think a lot of people don't realize how draconian this rule is for businesses.
It can be brutal.
Let's say a 17-year-old tech millionaire walks into a high-end dealership and buys a brand new $200,000 Porsche. He pays cash, signs the paperwork, and drives off the lot.
A terrible idea for the dealership.
Right. 3 days later, he decides he wants to see how fast it can go on a dirt road, loses control, and wraps the car around a telephone pole. The car's completely destroyed. It's just a smoldering pile of scrap metal.
Okay.
He takes the steering wheel, walks back into the dealership, drops it on the manager's desk, and says, I am 17. I disaffirm this contract. What happens?
Under the strict traditional application of the common law infancy doctrine, the teenager gets his entire $200,000 back.
You're kidding. That is genuinely shocking.
Yeah.
The dealership gave him a pristine sports car. He destroyed it through his own reckless behavior, and the dealership just has to eat a $200,000 loss.
They do.
Why doesn't the kid have to pay for the depreciation or the damage?
Because the entire architectural purpose of the infancy doctrine is a heavy-handed, almost punitive deterrent. The law is looking at the macro-level economic picture and saying, adults, under no circumstances should you do business with children. Period. If you choose to enter into a contract with a minor, you do so entirely at your own peril. You bear 100% of the risk of their immaturity, their lack of judgment, and their physical destructiveness.
Because if the courts allowed the dealership to deduct the cost of the damage,
it would incentivize businesses to take a chance on selling to minors, knowing they could recover their losses. The law wants an absolute freeze on youth commerce. When a minor disaffirms, they are only required to return whatever remains of the consideration in its current condition.
So if it's a wrecked steering wheel, that's what they return.
That's what they return.
Now, obviously, a society can't function if teenagers literally cannot buy anything without the seller risking total ruin. What if the kid isn't buying a luxury sports car, but is buying a winter coat because they're freezing, or buying groceries because they're starving?
You've hit on the major, heavily tested exception to the infancy doctrine, contracts for necessaries.
Necessaries.
Yes. The law recognizes that sometimes minors are emancipated or away from their parents, and they need to be able to participate in commerce to survive. Necessaries generally include food, shelter, clothing, and medical care.
So if a minor signs a lease for an apartment, they are legally bound to the contract just like an adult.
No, and this is the exact nuance that the bar examiners love to exploit. The minor is not bound to the actual contract. They still retain the absolute power to disaffirm the contract itself.
Wait, really?
Really. However, if the item was a necessary, the minor doesn't get off scot-free. Upon disaffirmance, the minor is held liable under a theory of restitution or quasi-contract to pay for the reasonable value of the goods or services they actually consumed.
Let's trace the math on that. A 17-year-old moves to a new city and signs a 1-year lease for a luxury penthouse apartment at $5,000 a month. The landlord foolishly lets him sign. The kid lives there for exactly 1 month, then walks into the office, says, I disaffirm, and hands the keys back.
The landlord cannot sue the kid for the remaining 11 months of the lease. The contract is voided.
Okay, but what about the first month?
The landlord also cannot necessarily sue the kid for the $5,000 for the first month. The court will look at what a reasonable value for basic shelter in that city would be.
Oh, I see.
If a basic studio apartment costs $1,000 a month, the court will force the minor to pay $1,000 in restitution under the quasi-contract to prevent the minor from being unjustly enriched by receiving free shelter.
So the minor avoids the luxury premium, but pays for the baseline necessity.
Exactly.
That is a brilliant compromise by the courts. It protects the kid from being locked into a terrible long-term luxury contract, but it ensures landlords aren't completely terrorized into letting runaway teens freeze on the street. Quick recap for the listener. Avoidable for the minor, but liable for reasonable value of necessaries.
Perfect recap. And the same logic of capacity extends to mental illness and intoxication. If a person is suffering from a mental defect that renders them unable to comprehend the nature and consequences of the transaction, the contract is voidable.
Is there an exception to that?
The exception is if a court has officially adjudicated the person incompetent and appointed a legal guardian. At that point, the incompetent person completely loses the legal power to contract. Any signature they put on a paper is legally void.
What about intoxication? Because this feels like a classic law school trope. The two businessmen get hammered at a steakhouse, pull out a cocktail napkin, and sketch out a multi-million-dollar merger.
Happens all the time in hypotheticals.
The next morning, one of them wakes up with a terrible headache and realizes he's sold his entire company. Can he void the napkin contract?
The bar for voiding a contract due to intoxication is notoriously incredibly high. Being drunk, having impaired judgment, or making a decision you wouldn't have made sober is not enough.
So what is enough?
To void the contract, you must be so profoundly intoxicated that you are entirely incapable of understanding the nature and significance of the transaction. You basically have to be bordering on catatonia.
But wait, if you're that intoxicated, how are you even holding a pen?
And that's exactly why the defense rarely works. But there is a second, equally important prong to the intoxication defense. It's not enough that you were blackout drunk. The other party must have had reason to know of your intoxication.
So if you hide it well,
If you are a highly functional alcoholic and you manage to negotiate a complex deal while heavily intoxicated, but the other party reasonably believes you are sober, the law will enforce the contract to protect the innocent party's reliance.
okay, so capacity looks at the person. But what if the people are of sound mind, over 18, completely sober, but the thing they're agreeing to do violates public policy? Let's dive into illegality.
Sure. Contracts that involve an illegal subject matter or require an illegal act are generally void and unenforceable. Courts will not allow the judicial system to be used to enforce a criminal enterprise. But for bar prep purposes, you need to understand how the timing of the illegality affects the contract formation.
What do you mean by timing?
Suppose we make an agreement today that I will import a specific type of exotic bird for you. If a law was passed last week making the importation of that bird a federal crime, our contract is void from the start. It never formed.
Okay, but what if the law isn't passed until tomorrow? So when we made the deal, it was perfectly legal. But before you can deliver the bird, it becomes illegal. Are you still liable for breach of contract because you didn't deliver?
No. If the subject matter becomes illegal after the contract is formed but before it is performed, the legal duty is discharged under the doctrine of impossibility or supervening illegality. Neither party is at fault, but the contract is dissolved.
Let me throw a curveball at you regarding illegality, focusing on licensing statutes, because I know this is a huge trap on the MBE.
It is. Let's hear it.
Let's compare two different people operating without a license. First, I go to a street fair, buy a hot dog from a vendor. I eat it, it's delicious. But then I notice his city vendor permit expired 2 days ago. He is technically operating an illegal food stand. Do I still owe him the $5 for the hot dog?
Yes, you absolutely still owe him the money. The contract for the hot dog is fully enforceable.
Okay, second scenario. I hire a lawyer to represent me in a complex civil trial. We sign a contract for a $50,000 flat fee. She does a brilliant job, wins the case, and saves me millions.
A great result.
But the day after the trial, I discover she failed the bar exam and forged her credentials. She is entirely unlicensed. She demands her $50,000. Do I have to pay her?
You do not owe her a single dime. The contract is entirely unenforceable.
Okay, unpack the logic there for me. Both of them were operating illegally without a required state or city license.
Right.
Why do I have to pay the hot dog guy but not the faith lawyer?
The law requires us to look deeply at the legislative intent behind the specific licensing statute. Why did the government require the license in the first place? If the purpose of the license is merely to raise revenue for the government, like a street vendor fee or a generic business tax registration, the courts hold that the lack of the license is an issue between the vendor and the tax authorities. It does not invalidate private contracts. The hot dog was fine. Pay the man.
But for the lawyer.
If the purpose of the licensing statute is the protection of the public welfare like medical boards, state bar associations for lawyers, or engineering licenses, the courts take a draconian stance.
Because they're dangerous.
Exactly. The legislature determined that unlicensed individuals in these fields pose a grave danger to society. Therefore, the courts will completely refuse to enforce any contract for their services, even if the service was performed flawlessly. They want to absolutely disincentivize anyone from practicing without a protective license.
That makes perfect sense. The law uses the enforceability of the contract as a weapon to enforce public safety. Okay, let's move into Section 4. We've established the parties are capable, the subject is legal, and everyone understands the terms. But what if one of the parties is only at the table because they are being coerced? We're looking at the defenses of duress and undue influence. Let's start with the most visceral. Physical duress versus threat-based duress.
The distinction here is stark, and it parallels the discussion we had earlier about fraud. Physical duress occurs when someone physically compels you to manifest assent.
Like what?
The classic law school example is someone literally grabbing your hand, wrapping your fingers around a pen, and physically forcing your arm across the paper to sign a document.
Obviously, that's not a real contract.
Legally, it is completely void. It is a nullity from the instant it happens, because there was absolutely no mental assent whatsoever. Your body was just used as a tool.
Right.
But contrast that with threat-based duress. Someone puts a gun to your head or threatens to harm your family and says, sign this contract. You pick up the pen with your own hand, under your own muscle control, and you sign it.
I'm signing it because I'm terrified. I want to save my life, but I'm making a conscious choice to sign it.
Exactly the distinction the law makes. Because your brain processed the threat and chose to manifest assent as the lesser of two evils, the contract is not void. It is voidable.
I struggle with this every time I hear it. If a mobster threatens to break my legs, why on earth would the law treat that contract as merely voidable instead of instantly void? Doesn't voidable mean it's legally valid until I take action to stop it?
Yes, it does. And that is a deliberate feature, not a bug, of the legal system. Think about the mechanics of power. If the contract was automatically void, it would mean neither party could ever enforce it.
Okay.
But what if the mobster forced you to sign a contract that actually turned out to be wildly financially beneficial to you? Or what if you want to use the existence of the contract as leverage against him in a different proceeding?
Oh, I see.
By making it voidable, the law places the power entirely in the hands of the victim. The victim gets to look at the situation once they are safe and decide, do I want to tear this up or do I want to hold him to it? The law refuses to take that choice away from the victim.
Okay, framing it as empowering the victim actually makes a lot of sense. But physical violence is pretty rare in corporate law. Let's talk about economic duress.
A much more common claim.
Right, because it feels like every major financial negotiation involves one party having more leverage and squeezing the other. If a massive corporation threatens to crush my small business by undercutting my prices unless I sell my patent to them, isn't that economic duress?
Usually, no. The bar for establishing economic duress as a legal defense to void a contract is incredibly high. Taking advantage of someone's pre-existing financial hardship or using superior market power to drive a hard bargain is considered standard capitalist practice.
It's just business.
It is the very engine of the free market. For economic duress to legally exist, you must satisfy two strict elements. First, one party must make a wrongful or improper threat. Second, that threat must leave the victim with no reasonable alternative but to agree to the contract.
Let's test those elements with a hypothetical. Let's say Barry owns a small diner. He has completely mismanaged his finances, and the bank is foreclosing on him building tomorrow. He is desperate.
Okay, poor Barry.
A wealthy real estate developer walks into the diner, sees Barry crying over the foreclosure notice, and says, Barry, I know your building is worth $500,000, but I will buy it from you right now in cash for $50,000. Take it or leave it.
Ouch.
Barry is weeping, but he needs the cash to avoid total bankruptcy, so he signs the deed. The next day, Barry feels extorted and tries to claim economic duress to void the sale. Does he win?
Barry loses. This is not economic duress.
But he had no reasonable alternative. He was going to lose the building tomorrow.
He might have had no reasonable alternative, but you are forgetting the first required element, a wrongful threat. Did the developer threaten Barry?
Well, no.
Did the developer cause the foreclosure? No. Barry caused his own financial ruin. The developer merely observed Barry's pre-existing desperate situation and offered a terrible, predatory, but ultimately legal lifeline. Taking advantage of a desperate situation you did not create is not economic duress.
Okay, let's tweak the facts. What if the real estate developer is also the president of the local bank?
Now we're talking.
And he walks into the diner and says, Barry, I know you are a month behind on your mortgage. As the bank president, I am going to illegally fast-track your foreclosure and destroy your credit forever, unless you sell me your diner to me personally for $50,000. Barry signs.
Now you have crossed the threshold into economic duress. The developer is making an affirmative, wrongful, and in this case illegal, threat to cause financial harm specifically to extort a contract.
And Barry still has no alternative.
Right, because the threat involves destroying Barry's credit and business, Barry likely has no reasonable alternative but to stave off the immediate, improperly threatened destruction. The courts will allow Barry to void that contract because the pressure was unlawfully created by the party seeking the benefit.
That is a phenomenal distinction, taking advantage of a fire versus setting the fire yourself.
Precisely. And there's one more defense in this category that deals with pressure but without explicit threats: undue influence. This is less about coercion and more about unfair persuasion.
Who usually claims undue influence? Is this the classic evil nurse stealing the inheritance scenario?
That is exactly the archetypal fact pattern.
Yeah.
Undue influence occurs when one party uses their position of power, trust, or domination over another person to unfairly persuade them into a contract.
So what do the courts look for?
They look for a combination of factors. They look at the vulnerability of the victim. Are they elderly, mentally declining, or emotionally dependent? They look at their relationship. Is it a fiduciary relationship, like a lawyer-client or a caregiver-patient?
Right.
And they look at the mechanics of the persuasion. Was the victim isolated from family? Were they rushed into signing without independent legal advice? If the court finds that the stronger party essentially substituted their own will for the will of the weaker party, the contract is voidable.
So quick recap for Section 4. Physical duress makes it void. Threat-based makes it voidable.
Yeah.
Economic duress needs a wrongful threat, not just a hard bargain.
Yeah.
And undue influence is about unfair persuasion in a relationship of trust.
You nailed it.
Okay, we have marched through a mass amount of territory. We've handled mistakes, lies, capacity, and coercion. Let's say a contract survives all of that. The parties meant the same thing. They told the truth. They are sane adults, and no one was pressured.
A miracle.
The agreement is conceptually flawless. We arrive at Section 5, which is arguably the most dreaded doctrine in a first-year law student's life, the statute of frauds.
It is feared because it feels so arbitrary. The basic premise is that for certain, highly specific categories of contracts, an oral agreement is simply not enough. The law demands objective, written proof that the deal was made.
So if it falls into one of these categories, and you don't have a signed writing, your conceptually flawless oral contract is generally unenforceable in court.
Exactly.
Let's talk about the history here before we get to the rules, because understanding why this exists makes it feel less arbitrary. The statute of frauds wasn't just invented by bar examiners to cause pain, right?
No, it dates back to the English Parliament in 1677. The official title was An Act for Prevention of Frauds and Perjuries. At the time, the English court system was plagued by people hiring witnesses to go into court and simply lie, swearing that an oral contract had been made for land or massive amounts of money.
Just a total perjury free-for-all.
Completely. The courts were clogged with he said, she said perjury battles. So Parliament drew a hard line. They identified the most valuable, most complex, and most easily fabricated types of agreements and said, we are no longer accepting oral testimony for these. If you want the court to enforce it, show us the paper.
And American law adopted that framework. To memorize the categories that require a writing, bar students use the legendary mnemonic device, MyLegs, M-Y-L-E-G-S. I won't walk through these, and I want you to point out the specific traps the examiners use for each one. Let's start with M, marriage.
Marriage does not refer to the actual oral promise to marry someone, like a standard proposal, will you marry me? Yes, that doesn't need a writing.
Good to know.
The statute of frauds applies to promises made in consideration of marriage. This means an agreement where marriage is the requested performance that triggers a financial or property promise.
Like a prenuptial agreement.
Exactly. Or a scenario where a wealthy father says to a suitor, "If you marry my daughter, I will deed you my summer house." The marriage is the consideration for the house. Because it involves property and the complex emotions of marriage, the law requires that promise to be in writing to be enforceable.
Okay, moving to Y year. Contracts that cannot be performed within 1 year. I know from the source material that this is heavily tested using the possibility test. Explain the mechanics of this test because it bends the brain a little bit.
The wording of the rule is critical. The statute applies to contracts that cannot possibly be fully performed within 1 year from the exact date the contract is made.
Cannot possibly.
The law does not care about probability. It does not care about realism. It only cares about theoretical impossibility.
Let's use an extreme hypothetical. I hire a single lumberjack, armed only with a hand axe. I orally offer to pay him $1 million to cut down every single tree on my 10,000-acre ranch. We shake hands.
Yeah.
Realistically, working alone with a hand axe, it will take him 20 years to finish. Is that oral contract enforceable, or does it need a writing because it will take more than a year?
It is fully enforceable as an oral contract. It does not need a writing.
But it will take 20 years.
But is it theoretically, physically impossible to complete the task in under a year? What if the lumberjack somehow hired 10,000 helpers the next day and they cleared the forest in a weekend?
Okay, I see.
It is logically possible to complete the performance, the clearing of the trees, within a year. Because it is possible, it falls completely outside the statute of frauds.
So what does fall inside the 1-year rule?
Contracts bound by an explicit, immovable measure of time. If I hire you and orally promise to employ you for exactly 2 years, that must be in writing. It is physically impossible to complete 2 years of labor in less than 1 calendar year.
What about a lifetime contract? I orally promise to pay for your nursing care for the rest of your natural life. Does that need a writing? Most people live longer than a year.
This is the classic MBE trick question.
Yeah.
A lifetime contract does not need a writing.
Why not?
Because you could walk out of the room and drop dead of a heart attack tomorrow. If you die tomorrow, the contract has been fully, completely performed according to its terms within a single day. Since it is logically possible to perform it within a year, the oral agreement is enforceable.
That is fascinating. The law prioritizes the logical boundaries of the text over the practical reality of the world. Okay, L is for land.
Any contract creating or transferring an interest in real property. This includes sales of land, mortgages, easements, and leases that are longer than 1 year.
Okay, so a short lease is fine.
A 6-month apartment lease can be oral. A 2-year lease must be written. And the writing for land is particularly strict. It must specifically describe the property and state the price.
E is for executor.
This is niche but important. When a person dies, the executor manages their estate. Usually, estate debts are paid from the estate's funds. But if the executor orally promises a creditor, "Don't worry, if the estate runs out of money, I will pay the deceased's debt out of my own personal pocket." That promise must be in writing to be enforceable. The law wants strong proof before it forces someone to pay another person's debts.
Which flows perfectly into G for goods and S for suretyship. Let's do S first.
A suretyship is a guarantee. It's an agreement to answer for the debt or default of another person. If your cousin wants a loan from the bank and you orally tell the banker, "Give him the money, and if he defaults, I'll cover it," that is a surety. It generally must be in writing.
I see an exception in the notes, though. The main purpose rule. What is that?
It's an inquiry into why you made the guarantee. If your main purpose in guaranteeing your cousin's loan was simply to do a nice thing for family, it needs a writing.
Right.
But what if your cousin is borrowing the money to buy a delivery truck, and he is going to use that truck exclusively to deliver goods for your company? Your main purpose in guaranteeing the loan is actually to benefit your own business. If the main purpose is self-serving, the oral promise becomes enforceable without a writing.
Okay, finally, we arrive at G goods. And this is a monster. We are leaving the common law and enter the Uniform Commercial Code, the UCC, specifically Section 2201.
Correct. The rule is simple on its face. A contract for the sale of goods for a price of $500 or more must be evidenced by a writing.
Okay.
And under the UCC, the writing is incredibly forgiving. It doesn't need the price, it doesn't need the delivery date, it only strictly requires one specific term: the quantity of the goods. A cocktail napkin that says, "I agree to buy 500 widgets from Bob," signed by the buyer, is a perfectly valid writing against the buyer.
But the UCC is famous for its commercial practicality, which means there are massive exceptions where an oral contract for $1,000 of goods will be enforced without a single scrap of paper. We need to drill down on these 4 major UCC exceptions.
Let's do it. Exception number 1. Specially manufactured goods. Suppose you run a local political campaign. You call a printing company and orally order $10,000 worth of custom T-shirts with your candidate's face and name printed on them.
Okay, no writing.
You don't sign anything. The printer buys the ink, sets up the machines, and prints 5,000 shirts. Then you call and say, "We lost the primary, cancel the order, and we never put it in writing, so I don't owe you anything."
Under the strict $500 rule, the campaign would win. But I assume the custom nature of the shirts changes everything.
Exactly. The statute of frauds is designed to prevent fraudulent claims of contracts. But if a manufacturer has created 10,000 shirts with your candidate's specific face on them, shirts that are utterly unsellable to anyone else in the ordinary course of business, the physical existence of those custom shirts is overwhelming, tangible proof that a contract was made.
So I have to pay.
The law says the manufacturer's substantial beginning of performance substitutes for the writing. You owe the money.
Exception 2. Goods accepted and paid for.
This is common sense. If we orally agree, I will sell you my tractor for $2,000 and you hand me the $2,000 and I hand you the keys, neither of us can go to court a week later and try to void the sale by claiming it wasn't in writing.
Because it already happened.
Right. The physical exchange of the money and the goods fully satisfies the evidentiary requirement of the statute of frauds.
Exception 3. Admission in court.
If you are sued for breaching an oral contract for goods over $500, and during a deposition or in a court pleading you admit, "Yes, we agreed to the sale, but I'm not paying because it wasn't in writing,"
You lose the defense.
instantly, the entire purpose of the statute is to prevent perjury about the existence of a contract. If you admit under oath the contract existed, the statute has done its job, and the oral contract is enforced against you up to the quantity you admitted.
And exception 4, which sounds incredibly dangerous for businesses, the merchant's confirmatory memo.
It is dangerous if you aren't paying attention to your mail. This rule only applies when both parties are merchants professionals in the business of buying and selling goods.
Okay.
Suppose 2 merchants agree on the phone to a $50,000 lumber sale. Merchant A goes back to his office and types up a formal letter confirming the terms and the quantity, signs it, and mails it to Merchant B.
Merchant A has now signed a writing. So Merchant B could enforce it against A. But Merchant B hasn't signed anything.
Under the common law, you're right, it would only bind A. But under the UCC Merchant's Confirmatory Memo rule, if Merchant B receives that letter, has reason to know what's in it, and fails to send a written objection within 10 days, that single piece of paper satisfies the statute of frauds against both of them.
So a merchant could be bound to a massive contract simply by throwing a piece of mail in the trash and ignoring it for 11 days.
Yes. The UCC expects merchants to act like professionals. If someone sends you a confirmation of a major deal you supposedly made and you didn't make it, commercial standards dictate that you immediately respond and say, "We never agreed to this." Silence is penalized.
I want to wrap up the statute of frauds with a question about modifications. Let's say we have a written, signed contract for a 1-year lease. A month in, we orally agree to drop the rent by $50. Is that oral modification valid?
You have to look at the contract as modified. Does the newly modified deal still fall inside the statute of frauds? In your example, a lease with 11 months left doesn't fall inside the 1-year rule, so an oral modification might be valid.
Okay, but what about goods?
Let's look at goods. We have a signed contract for 400 widgets at $1 each. That's $400, no writing required, but we wrote it anyway. Later, we orally agree to change the order to 600 widgets. The modified contract is now $600.
It crosses the threshold.
It crosses the UCC threshold. That modification must be in writing, or the original 400 widget written contract stands.
Okay, let's do a quick recap of my legs. Marriage, year, land, executor, goods over $500, and suretyship. And for the MBE, remember the Y possibility test and the 4 UCC exceptions for goods.
Perfect summary.
We've covered the mechanics, the paperwork, the lies, and the capacity. But there is one final trapdoor in Chapter 4, Section 6, unconscionability. This feels like the ultimate sweeping safety valve of the judicial system. What happens if a contract checks every single box we've discussed today? Signed, sealed, capable, truthful, but the result is just sickeningly, oppressively unfair.
The doctrine of unconscionability is the court's ultimate veto power. It is the legal system acknowledging that sometimes strict adherence to contract mechanics produces a result so profoundly unjust that enforcing it would damage the integrity of the courts themselves.
How does a court measure fairness? That seems incredibly subjective.
It is, which is why courts are generally very hesitant to use it. They use a specific framework to evaluate it. Crucially, unconscionability must be evaluated based on the circumstances that existed at the exact time the contract was made.
So you can't just change your mind later.
No. You cannot suffer a massive financial loss 3 years into a deal and suddenly claim it's unconscionable. It had to be poisonous from day one.
And the source material divides this poison into two categories: procedural and substantive. Let's start with procedural unconscionability. What does the formation process look like if it's procedurally unconscionable?
Courts look for a massive defect in the bargaining process itself. They look for unfair surprise, like hiding a massive penalty clause in 4-point font on page 47 of a document. They look for a profound inequality of bargaining power. This is where we analyze contracts of adhesion.
Take it or leave it contracts. Like when I click, I agree on a 100-page software update, or sign the boilerplate form at the rental car counter. I have zero power to cross out a line and negotiate with the rental car clerk.
Exactly. Now, contracts of adhesion are a necessary reality of the modern economy. They aren't inherently illegal. But they satisfy the procedural element of unconscionability because you had no meaningful choice. If a contract is procedurally suspect, the court then looks to the second element, substantive unconscionability.
So procedural is how the sausage was made. Substantive is what the sausage actually is.
Perfect way to frame it. Substantive unconscionability looks at the actual terms of the deal. Are the terms objectively oppressive? Do they shock the conscience of the average person?
Give me an example.
If that rental car contract of adhesion contains a clause that says, if you return the car a day late, you forfeit ownership of your home to the rental agency, that is substantively outrageous.
Usually, a court requires both procedural and substantive elements to throw out a contract. They want to see that you were forced into a corner and the terms you were forced to accept were monstrous.
Yes. And on the MBE, you will rarely see unconscionability as the correct affirmative answer to invalidate an entire commercial agreement between two businesses. Businesses are expected to protect themselves.
So when does it show up?
You are much more likely to see it as a trap answer, or applied in a consumer context where a massive corporation attempts to completely disclaim all liability for physical injuries caused by their own defective product.
Oh, that makes sense.
Furthermore, if a court finds a clause unconscionable, they don't have to torch the entire contract. They use the doctrine of severance, they surgically cut out the oppressive clause, and enforce the rest of the reasonable agreement.
We have spent the last hour dissecting the anatomy of a broken deal.
Yeah,
To tie all of these threads together, I want to step back and look at the big picture.
it's a lot to take in.
It is. We started with honest mistakes, where the law forces us to decide who assumed the risk of the unknown, like the topaz that turned out to be a diamond. We navigated the treacherous waters of fraud, drawing that incredibly sharp line between being tricked into a bad deal, which is voidable, and being tricked into signing a paper you didn't even know was a contract, which is entirely void.
Void ab initio.
Exactly. We looked at the extreme, almost punitive protections afforded to minors and how the licensing of hot dog vendors versus doctors changes everything. We walked through the economic realities of duress, separating the brutal forces of the free market from actual wrongful extortion.
The diner example.
Yeah. We traced the history of the statute of frauds back to 1677, forcing massive deals, lifetime promises, and custom T-shirts through the rigorous filters of my legs. And finally, the overarching safety net of unconscionability.
It is an incredibly dense thicket of rules. But I hope that by discussing the underlying tension, the why behind the laws, the rote memorization becomes much easier for you.
Absolutely.
The bar examiners aren't just testing your memory of the UCC, they are testing your understanding of how the law balances the aggressive need for commercial stability against the fundamental human desire for fairness.
And that leads me to a final, slightly philosophical thought for you to chew on as you close your books today. We spend so much time in law school and business assuming that the ultimate goal of contract law is to bind people to their promises, to create certainty in an uncertain world.
It's the whole point of a contract.
Yet, as we've seen today, The legal system has spent centuries engineering an incredibly complex, labyrinthine system of trapdoors designed specifically to let people escape those very promises.
It's a fascinating paradox.
It forces us to ask a difficult question about the nature of commerce. Does knowing exactly how easily and under how many hyper-specific circumstances a legally binding contract can be utterly unraveled make you more likely to trust a handshake or entirely terrified of one? Think about that the next time you uncap your pen. Keep grinding on your prep, keep questioning the mechanics behind the rules, and we will see you on the next deep dive.